Staff, attorney points to the docs, number 79657. Welcome my client, Mr. Sean Glover.
Morning. Your name?
Deshaun Glover.
All right. What are we doing today?
Your Honor, I am going to ask for another PCC. I know I didn't fill out this.
He didn't fill out the form.
I didn't fill out
He
the
was just
form.
going to march up here.
And I was told
he was
to.
just going to march up here and just do it. And I'm supposed to just not. He marched up. He came up. He said, I'm not following that rule. I don't care what that judge says. He was saying all that. I could hear it all the way up here saying that. And then,
Your Honor, I would like to address bond.
how much time did you need, counsel?
Your Honor, I would just need a short adjournment, 2 weeks.
Sure,
is fine.
2 weeks. All right. Probable cause conference will be adjourned December 5th, 2024, 9 a.m. Yes, as to bond.
Yeah, Your Honor, as to bond, Your Honor, I spoke with his mom. They have retained counsel. Obviously, you know the requirements. He's not going to be a flight risk, Your Honor. This is my client works with his uncle. I can verify the company. He does landscaping. They're doing snow removal right now, and we're asking for a lower bond, Your Honor, if we can even do.
This guy walked into the courtroom like he was about to do stand-up at an open MIC night. No structure, no game plan, just pure vibes. No legal strategy, no documents in hand, just raw confidence like he was going to freestyle his way through a felony case. You could practically see the judge and prosecutor thinking, is this guy serious right now? And then it really hits. The prosecutor looks at him like, you actually thought you could stroll in here and just wing a case like this? The disbelief in the room was immediate. We're not even a full minute into the hearing, and the energy is already chaotic. It's one of those moments where you can just feel the tension and secondhand embarrassment setting in. Buckle up, this one's going off the rails quick.
Fine for right now, for my client.
Response from the people.
It's threefold. One out of Taylor for $400, one out of Clint for $3,000, and one out of Genesee for $500. He has 2 prior convictions for fleeing third, one from 2010, one from 2015. Beyond that, the nature of this case is concerning in itself. The charging ETA on this actually requested a $500,000 cash security for $150,000. In this particular case, the defendant went to the Comfort Inn to have sex with the victim. The defendant and the victim got into an argument, after which the defendant chased the victim with his car and almost ran her over. Law enforcement arrived on scene and observed the defendant's vehicle and observed the victim exit the vehicle and enter the hotel. On contact with law enforcement, the defendant admitted to chasing the victim in the parking lot, but denied hitting her. When the law enforcement contacted the victim, she was visibly distraught and expressed fear of speaking out against the defendant because of potential retaliation concerns. The victim advised that she previously tried to leave the defendant, but he wrecked his car, and when she tried to get her own apartment, the defendant showed up with a baseball bat and began breaking things. And then after he was breaking things, he said, "Are you still leaving?" The victim also advised that the defendant has quote unquote people who will hurt her if she speaks out against the defendant. I mean, at this point, I'm significantly concerned. I want to lower than we originally asked for. I understand it's high, but I don't think reduction is appropriate.
Your Honor, as an officer of the court, I think the victim, she has called me 2-3 times, and they were in a relationship, dating relationship, Your Honor. So that was his girlfriend, and it still is his girlfriend. So I'm not exactly sure what the nature of the victim and what the sister counsel is referring to, but that is my client's girlfriend. They've been in a relationship for a couple of years, Your Honor, and she has called me as recently as today, as to try to advocate for my client.
I think, given the statements that she made to law enforcement, it's pretty clear potentially why she would be motivated to do that if she has concerns about retaliation, if she were to participate or do anything other than advocate for the defendant. So I don't think that a release would necessarily.
Let me make sure I've got this right. He allegedly chased this woman down in a car, showed up at her place wielding a bat, made threats about sending people after her, and his entire defense is that she's still his girlfriend? What kind of twisted, horror meets romance plot is that supposed to be? That's not love, that's a red flag factory in motion. This isn't some dramatic relationship drama, it's giving serious protection order territory. The behavior described here crosses way past emotional chaos and lands squarely in dangerous, possibly criminal territory. If this is his idea of affection, someone needs to remind him that the courtroom isn't a set for a toxic soap opera. Let's keep watching, because this case is unraveling.
No, sir.
Okay, but I guess what I'm getting at is that charge count 2 is the transportation of a person across state lines to assist in prostitution. And that individual named.
Yeah, and we are miffed with that.
Pardon?
That we're confused why that was charged, and for the nature, it has nothing to do with any of the police report had anything to do with prostitution or anything like that. Even the victim herself didn't state that she was there to do that. We were just confused and surprised, Your Honor, by that. And obviously, talking with her, that she's mentioned to me several times with her talking with her mom, his mom. She's called me several times. I said this morning, and took his car when the incident happened, drove it back to Flint, Your Honor. So this is not what that police report alleges.
Well, I'm okay. Then I'm going to need some further clarification on that before I do anything regarding bond on this. So at this juncture, I'm going to.
This charge seems to appear out of thin air. Seriously, no one in the room, not even the defense team, knows where it came from. It's like the legal system just hit the shuffle button on a playlist of felony charges and landed on this one by mistake. Everyone's flipping through documents, trying to make sense of it. And even the judge looks genuinely confused. It's one of those moments where bureaucracy overrides logic, when paperwork starts speaking louder than the actual facts of the case. And instead of clarity, you get chaos in the courtroom. You can tell this wasn't part of anyone's plan, and now everyone's scrambling to catch up. Let's see how they untangle this legal.
He was.
What?
He got probation violations as a result of this charge, Your Honor. The circuit court gave him PRs on their matters.
On the violations?
On the violations.
Is that the people's understanding?
I don't know. I'm trying to get through his 26-page criminal history, but if I'm understanding correctly, he told half of $1,000 of this case. He asked just for an in-custody date so we can get all the matters before Judge Kunke. And I don't think a PR bond is appropriate. The allegations in this case are that the defendant was masturbating in front of a female corrections officer. So if he's certainly willing to do that in custody, I do believe that he could be a danger to the community if he's out of custody. And if he doesn't have.
And just like that, it's over. You could almost feel the energy shift instantly, like the air got sucked right out of the room. The moment that accusation was spoken, everything changed. No matter how skilled his lawyer is, no matter what arguments they try to make now, it's hard to recover from a moment like that. Danny. In other words, the judge is basically saying, yeah, I'm not getting involved in this disaster. Let someone else handle it. And honestly, that's a move I respect. Some situations are so tangled, so explosive, that stepping in only guarantees you get burned. Sometimes the smartest thing to do isn't to take control, it's to send it up the chain and let the next court sort through the chaos. This isn't dodging responsibility, it's knowing when a case is too volatile to resolve on the spot. That's not weakness, it's wisdom.
It's not home confinement.
Well, I understand that, but so when this, so why was he in custody
Before this
to
happened.
even be able to commit this offense?
Is it my understanding, Mr. Word, that you were waiting on getting a PSI done?
This case is from February when I was locked up.
And you were locked up in February because of the cases that are before the circuit court now?
That's because of the cases that was PR bond to me.
Because what?
Because of the cases that was
Yes.
PR bond.
The circuit court matters, Your Honor.
So these offenses he committed while on
While I was in
bond, but while he was incarcerated on another case.
yeah. And they didn't charge me with it until I just recently
Thank
got locked up.
And Your Honor, he was arraigned on October 28th before Judge Slay. He had the hearing before Judge Conkey, who then gave him a PR, and that was on the date of 10/31. So he's had a PR on those matters. And it's just been on this.
Well, I'll tell you what, he's gonna be up before. I don't think it's appropriate to let him out on a PR given the circumstances, but I'm sure Judge Conkey may feel differently having given him PR on the probation violation. So I'm gonna deny the request.
This moment really hits differently. He's calm, polite, and holding it together, but you can see the exhaustion written all over him. 38 extra days spent sitting in a cell, not because of new charges or bad behavior, but simply waiting on a piece of paper to move through a backed-up system. Think about that. His freedom was
past my ERD,
Gotcha.
and this is the only reason.
Okay.
Yeah.
So when can we get a nollie press down today?
I think that's very likely.
Okay, thank you for letting us know that. They're gonna get the nollie press down to me. I'll sign off on it. It'll be in the file. Now, how it gets to anybody, I don't know. But
Okay.
we'll do what we need to do on our end.
Thank you so much, Judge Simpson. It's good to see you. I watch you on court cam all the time.
Thank you, sir.
literally held hostage by a jammed process, stuck behind a fax machine and bureaucratic delays. When someone's liberty hinges on whether an office printer works or not, that's not due process. That's a broken system. And it's moments like these that remind us how far we still have to go in the name of real justice.